Okay, concept 4. Discuss the social and labor legislation and show how it reflects the new value of society that business has rights as it always has, but it also now has responsibilities to society. Until the 1930s, American social and labor legislation lagged almost a generation behind that of more progressive European states like Denmark and Germany. Before the New Deal of the 1930s, labor and social legislation lay for the most part in the domain of the individual states, such as Massachusetts, New York, and Oregon. Throughout the 19th century, few authorities contested the right of the government to protect society and individuals against anything that threatened the general welfare. However, it was generally felt that the role of government protection was the responsibility of the states and not the federal government. But when more progressive states passed social and labor legislation, the collective impact of these laws was ineffective and not very impressive. Powerful vested interests such as manufacturers and landlords threw their weight against any kind of social legislation. And since such laws ran counter to the American traditions of individualism and laissez-faire, they often succeeded in either defeating them or making them inefficient and ineffective. The enemies of state social legislation discovered the 14th Amendment to the Constitution, a very effective weapon. This amendment imposed a revolutionary restriction on state power, for it provided that no state could, quote, deprive any person life, liberty, or property without due process of law. This gave conservative judges the power to curb trends which seemed to them to lead towards socialism and narrowed state police power. Three examples of labor legislation. So the first would be the minimum wage laws, which for many, many years were unsuccessful. So for many years, basically wages were based on what the market could bear. So if the market bared that you work for a nickel a day, that's what you would get paid. So beginning in 1912, however, Massachusetts enacted the first minimum wage for women and children. Within a short amount of time, 14 states had followed suit. In the famous case of Children's Hospital of the District of Columbia versus Adkins in 1923, the Supreme Court of the United States held that a minimum wage law was unconstitutional on the grounds that minimum wage laws violated the freedom of contract. The court reasoned that in arbitrarily fixing a wage on the basis of the employee's minimum cost of living, the law might be requiring the employer to pay more than the services were worth, and thus take the employer's property. That was basically the capital's argument. It was not until 1937 that the Supreme Court reversed its decision and held that minimum wage laws were constitutional. The difference between 1923 and 1937, of course, was the Great Depression and the New Deal, an example of government doing for the people what the people could not do for themselves. And we'll talk more about that, of course, when we get to the lecture on the New Deal a few weeks from now. In 1938, Congress passed the Fair Labor Standards Act, which set the first minimum wage at 40 cents an hour and the maximum work week at 44 hours to be lowered in 3 years to 40 hours. The requirements were limited to business engaged in interstate commerce at first. Another series of laws that were badly needed were in the area of workmen's compensation. The philosophy which developed here was that if the worker accepted the job, he must also accept the risk of the job. The employer, buyer beware, in other words. The employer was not responsible for accidents which happened to the employee because of his own negligence or that of a fellow worker. If one lost a hand or arm, tough luck. Most European nations had workmen's compensation by the turn of the century, but the United States lagged behind them again. It was not until 1917 that the Supreme Court upheld the New York States Compensation Act, and the majority of the states could develop their own workers' compensation program. Within a few years, all states except some southern states had workers' compensation laws on the books. Finally, another area which needed attention was unemployment and retirement. Americans' early industries provided nothing for workers who had outlived their usefulness. So once they got to a certain age, basically they were done. These workers were supposed to fend for themselves or to live off charity and or their children. Again, European nations took the lead by providing unemployment and old age pension programs even before the turn of the 20th century. So in the late 1800s, in other words. It was not until the Social Security Act of 1935 during the New Deal that our nation took appropriate action. The overall trend before the New Deal was that business took in the profits and left the social problems which developed as a result of its practices to society to handle and pay for. As a result, the new social legislation, society made business responsible for some of the problems it helped to create. So a new value emerged. Business had rights and it had responsibilities. So we're beginning to see this slowly emerge at the early part of the 20th century and start to become institutionalized on a national level as we get towards the New Deal. And we'll go into more detail in that when we get to the New Deal. But thank you. That's Concept 4. Do let me know if you have any questions, concerns. You can email me. If you're in one of my classes, you can talk to me in class. Or do both. I'll talk to you guys later. Go forth and be great.